listening to Driving Law, a podcast by Kyla about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla at Acumen Law, and with me, my co-host, Paul Doroshenko.
Hi, Kyla. Happy Friday.
Hi. Like we haven't been in the office for hours already today.
That's true.
Yeah.
Lots going on.
Hi. More like, yeah, lots going on.
Yeah, like some weird, stressful things in our lives, both of us.
Yep.
Not really related to loss.
Not
Like
related to driving law.
just those things that happen, but you're like, ugh.
Yep. But weird, stressful things in people's lives. I guess our lives are a lot less stressful than Mark Carney's life.
Mark Carney's life is stressful, one would imagine, because our unemployment has jumped up significantly. The highest it's been like since the pandemic, and the previous highest time it was like this was 2016. We are, I suspect, headed into a recession. It's the Donald Trump recession, which is going to hurt Americans, but going to hurt us a lot. The federal government is going to have to tighten its belt. At the same time, it's looking at where it can spend money to try and keep the economy doing well. And now it's got an issue that it's got to deal with respect to
driving law.
Driving law.
So if you remember, under the Trudeau government, there was an EV mandate that was put into place that had targets for the number of vehicles sold that had to be electric vehicles, essentially to eventually phase out gas-powered vehicles for climate reasons.
And this was also coordinated with the U.S.,
Yes.
Where the Biden regime had done something similar, recognizing our climate change catastrophe.
Well, and we had good trade relationships then. So with our automotive industry and their automotive manufacturing industry, it made sense
to do this now, to compel this. And now they're looking at it, and under pressure from the North American automotive manufacturers, so GM, Ford, and Stellantis, which owns Chrysler, Dodge, Ram, they are looking at completely dropping it.
Yes. So right now they paused the EV mandate. For 2026, it was supposed to be 20% EVs, electric vehicles. I should probably define that. 20% electric vehicles, and that's being put on pause. And there's going to be an immediate 60-day review of the mandate. So somebody in government is going to look into the mandate. They're going to review it, going to see if it actually makes sense fiscally anymore. It's interesting because this is like one of many sort of carbon initiatives that Mark Carney has scrapped, the carbon tax being the popular one to scrap, and the, income hurting one. This one might be a income generating one.
Well, it's less of an income generating one than what I look at, sort of nudging these American and Canadian manufacturers along, is where there was huge value in it. And in the end, I suspect that they're basically going to be overrun by Chinese manufacturers who are producing all electric vehicles. And we've got 100% tariff right now on BYD, but BYD has the capacity to produce all the vehicles for everywhere in the world, electric vehicles. And electric vehicles are categorically 100% better for the environment than gas-powered vehicles. It doesn't matter how you look at it, mining the minerals, everything, re-refining the batteries, you name it.
But you still dislike them. You've been so critical of electric vehicles, the battery fires, the difficulty with them, the weight affecting our roads.
These are just issues that have to be dealt with. It's not an issue of me being critical of them for the long run. They are the way to go. You're not burning gasoline and releasing contained carbon into the atmosphere and carbonating our atmosphere.
But part of the announcement today also included a $370 million investment into a 2-year thing to increase canola production, and then that canola is going to be used for a biofuel production incentives, and there's going to be a review and probably amendments to the clean fuel regulations.
Well, we've got a few things happening there. So you've got what will turn out to be a glut of canola because we've lost our Chinese canola buyers as a result of tariffs that they've imposed on us because of tariffs that we imposed on their vehicles. That was their response. China's response to our tariffs on their vehicles was to tariff the shit out of canola. And so we got a bunch of farmers who are panicking right now. And so this is just throwing a lifeline out to them. It's some sort of socialism for them.
So what you're
For the American manufacturers, hang on, that want to continue to produce gas guzzling pickup trucks, because that is a huge way for them to make money. We are also throwing them essentially a lifeline at the same time that Trump is tariffing the steel, the aluminum, and all of the stuff that needs to be produced going back and forth across the border. This is just the unstable times of it. And unfortunately, I guess my point is that this nudging them along was really an attempt to bring them up to speed with China. And they are going to face instead the competitive aspect of it, which is much more harmful for them in the long run. One day it's going to end up opening up. There's going to be more pressure to open up if Trump takes away so much more of the Canadian manufacturing of cars and trucks. We are not going to be in a position where we say, well, we're protecting our auto industry anymore by restricting Chinese imports. We better start cutting the tariffs on Chinese imports. And then they're not going to be able to compete because their products are going to be deficient. And so I'm not happy about seeing this happen, because I think that it was better for the automotive companies in the long run to be up to speed and to be putting the emphasis and development on this. But you've got to face the reality. And the reality is right now we're living next door to Trump's America.
Well, you cut me off and told me to hang on. And now my joke isn't even funny anymore, which was to save our country, we all should switch to margarine.
Yeah, for canola, I'm buying canola.
To do what with?
I wasn't a big canola. I used to buy corn oil. The only corn oil that I could find was Mazola. I used to just prefer corn oil. Mazola is American. I stopped buying it. Now I'm buying Canadian canola.
Okay. Well, I was just making a joke about eating margarine. Anyway,
Eat
my joke has been downtrodden.
Butter's good too.
It's fine. Okay.
Canadian dairy.
Moving on from that, we'll see how all this pans out. I don't know that I'm so pessimistic as you. You used to be so happy about Mark Carney, and now you're sad about Mark Carney.
No, I'm not. I think as he said all along, he's a realist and a pragmatist, and that's what I'm looking for good management.
Okay. Speaking of good management, the Saskatchewan Court of Appeal is continuing to do a good job managing charter rights.
The Saskatchewan Court of Appeal has been on a roll for years, and I wish we could
Yes.
swap them out here in BC.
We just swap them out with the Supreme Court of Canada.
We could. This new case that just came out, when did it came out? Heard back in January, but just released in the last week.
September 3rd.
September 3rd.
And
Wow.
it's a refusal case. Saskatchewan Court of Appeal. I can't pronounce that name. Amarua.
Yeah. So I guess Rex. I'm just going to say R and Amarua 2025 SKCA 83.
Yeah.
And the decision is written by Justice Kilback.
Shout out to Peter Sankoff, by the way, whose book is cited in the judgment.
Well, he's one of the co-authors of it. It's an interesting case. I mean, it's an interesting case from the start of the facts of it that don't end up being that crucial in it. It ends up being a pure legal issue, which is kind of nice to see at the Court of Appeal. But the facts of the case were also very hard to reconcile with the conviction. You've got an individual who has a collision with a police vehicle. And as a result, a mandatory ASD demand is made. I don't know if that was right to start with in those circumstances, but a mandatory ASD demand was made. And the fellow had something in his mouth the entire time and got flow INS the entire time. And ultimately, the question was essentially something that I thought was kind of long settled, but it had gone awry in the last little while, whether or not there's more than just the demand that has to be made, that there's an intent to basically thwart the process. So the demand is made, it has to be a lawful demand. That's the first step. The next step is the person is trying to provide a sample. And some took the position, and there's court decisions that took the position from other provinces, that if the sample had not been obtained, then it switched to you to provide a reasonable excuse.
Right.
Without any looking at the process to see whether or not you intended to thwart the process. Like it was.
And we have discussed before on this podcast the decisions that have been coming out, finding that the burden of proving a reasonable excuse being on the accused is no longer present in the criminal code because of the amendments that were made in C-46 and C-51. And so now the reasonable excuse is determined based on just raising an air of reality, and then the Crown has to rebut that.
So this decision is such a great read, and if you're a law student, just dig into it because it covers so much of the criminal law. Because the court stops and says, "Look, you have to look at basic criminal law principles here. Long established to determine the mental fault requirement for a particular offense, one begins with a presumption that Parliament intends for criminal offenses to have a subjective fault evidence. The presumption embodies one of the defining foundational values of the Canadian criminal law system, that morally innocent people should not be punished. Courts have identified particular words that tend to indicate particular standards of fault. For example, the words willful, knowing, knowledge, intent, and reckless suggest a subjective standard of fault, whereas words such as dangerous, negligent, due diligence, careless, reasonable, and duty tend to indicate an objective standard of fault." And ultimately, the court goes through and says it's a subjective standard of fault.
Yeah, because knowing that a demand has been made.
Yeah, because that's the first step of it. And then essentially comes to the conclusion that, look, like we in Canada, there are times when there's a duty, and when you have a duty, it's different. And in duty situations, it's usually a duty where you're in the powerful position, like you're a teacher with a duty.
What do you have in Canada? Sorry.
Certain legal duties.
There you go.
And the certain legal duties usually arise when you're in a position of authority or power. And that's not the position that you are when you are being subjected to an ASD demand.
Heck no.
You're not in a position of power. The police are in the position of power. And so it's not one of those legal duties that would create a objective mens rea. So there has to be a mental intent. Now, this is, to my knowledge, been the law in BC ever since Luco decision came out, which was a Saskatchewan decision from 20-something years ago, 2002 or something like that, and wasn't really an issue for debate. There's a couple of steps. Step one, lawful demand, and the person knows there's a lawful demand. They understand that there's a demand has been made of them. Step two, you have to establish, and it's not that hard in many cases, establish that they intended to thwart the process. And step three is that there's a reasonable excuse. But without step two, you would have so many people who could not provide the information that would substantiate the reasonable excuse.
Yeah.
And there's so many people, because you don't know what's going on in that device. You don't know whether or not that device is functioning perfectly on that day. We see some police officers where we get refusal case over and over. And then there's some police officers, you never get a refusal.
Well,
so how can it be that it's just purely you have to show a reasonable excuse?
Well, and also you have, I guess with body cams becoming more prevalent, this will be less of an issue, but the instructions the officer gave, you might never know or be able to properly recreate those. The status messages, there's been court decisions that have been critical on officers for failing to record status messages, but you and I know how often they actually record them.
But you also can get status messages that are not, that give no indication about what the person's doing wrong.
Yeah. And then there's the fact that you also, you could be having some sort of a biological issue that you can't get medical evidence about. Like, yeah, if you have something, systemically wrong with you, like lung cancer or COPD, you're going to be able to, after the fact, go to your doctor and get that medical evidence. But what if you just have like a really bad cold? What if you have COVID? right? You don't know. You don't know that you have it. And by the time you go to your doctor, you've cleared up. It's not like people just have family doctors anymore.
There's a significant portion of the population who are on the verge of not being able to provide a sample on any given day because of their physical condition, their state, their size, their just overall health, or some other disability. They might be able to do it when they're not standing at the roadside with a police officer shouting at them. In those circumstances, they might be able to do it in our office.
Yep.
Some people haven't been able to do it in our office because they are that freaked out just providing a sample here. So this is just such a clearly well-reasoned, thought-out case that rejects this Crown contention that all they had to do, because of the change to the legislation that came in 2018, all they had to do was prove that the person knew there was a demand, and then the onus switched to them to prove that there was a reasonable excuse. No, the court says, hang on, that is completely inconsistent with Canadian criminal law principles, and explains why, lays out the principles. Brilliant decision. I wish we got decisions with this clarity all the time, but we keep getting them from the Saskatchewan Court of Appeal. And you know why?
IRP scheme?
Pragmatic farmers.
Well, I thought IRP scheme, you're not prosecuting so many impaireds, much less getting them to appellate level.
I mean, I think there is some advantage to having people who've grown up in rural areas and have practiced all sorts of different law, not corporate law in downtown Vancouver on Howe Street or whatever, and have experienced much more in their lives, have maybe grown up in not in wealthy families on the west side.
Okay, fair. Now, there was another good decision that came out recently from Ontario, but it's just a trial court level decision. So it's not exactly going to have as much persuasive value as the Saskatchewan Court of Appeal will.
But all the reasoning makes sense.
All the reasoning makes perfect sense. And, I was reading this decision. It's about the right to counsel and implementing the right to counsel. And I was reading it. I was thinking back. Do you remember that case we had in Victoria where our client asked to speak to a lawyer and the officer handed him the yellow pages and he just flips through it like he'd never seen it before?
You've never seen the yellow pages. They've never seen the yellow pages.
20-something?
I mean, maybe if you're young and you're hearing us, you don't know what the yellow pages are, but the yellow pages were a big book that contained phone numbers and ads for businesses of all sorts, including lawyers. And when I started off in the office that we were at, we had a 2-page spread, the first 2-page spread as a criminal lawyer. And that thing cost like $12,000 a month. So you buy your annual one and they would bill you every month. And that was to get clients to come in. And when I found out that our clients were paying that much money for them to find us, I was taken aback. I did not like it. And that's the thing that I liked about the internet was there's the equalizer there. Of course, now you still the prices have gone up for things on the internet, but when it came out, you can find us, and it didn't cost us a lot to advertise then.
Well, there's also the big antitrust lawsuit involving Google, suggesting that they're, toying with the rankings, the organic rankings based on who's paying.
Well, they're toying with the organic rankings based on who's paying, but it's not always to the advantage of the person who's paying. Sometimes they're trying to get other people to pay, so they toy with the organic rankings for that. Google swore that they would never not do evil, and
If evil's profitable, it makes it very easy for billion-dollar companies, trillion-dollar companies. All right. So the case. So this woman, young woman, little girl, not little girl, but she's small, not a threat. The fact that she is not a threat to the police is emphasized multiple times in the decision, so you need to bear that in mind. She's pulled over, investigated. She's read a breath demand. She ultimately refuses to comply on the basis of the fact that she didn't get to talk to her lawyer. She asked for a specific lawyer. The officer looks up the lawyer. The lawyer's office permanently closed.
Looks up the lawyer on the internet.
Yeah.
Finds that the lawyer is retired.
On the internet, finds they're retired, tells her your lawyer's not viable, pick someone else. And she's very insistent. I'm not going to use duty counsel. I want to choose a lawyer. Let me go online and give me my phone so I can search for a lawyer. And they didn't do that. They offered her a lawyer directory, but it was outdated and there was no real evidence of what was contained in there.
It's usually just a list of lawyer names, 16,000 lawyers
Yep.
listed in a directory. They
And-
used to create those things. Haven't seen them in
Yeah.
years.
And a book of lawyers, but again, she rejected that. She said, there's no information about these lawyers. I have no biographical information. How am I supposed to choose the right lawyer when I don't even know anything about them?
Yeah. And, but she asks very clearly, give me my phone or let me have access to the internet, essentially. And the words told to her are, we're not going to do that. Something along that line.
Now, there was a little bit in this judgment that I also think, unrelated to the 10B issue, or I guess relatedly, is
That's not how it works. That's not how it works, what she was told.
the judge also makes a determination, and this is super important, and I don't know that you skipped over that or what. And it's this issue of refusal and whether or not you the actus reus of refusal. So we were talking about mens rea in the last case. The actus reus of refusal can be made out if a person doesn't get access to counsel when they've requested it. So even before or after the attempt to provide a breath sample or the refusal to provide a breath sample, if they ask for counsel and they don't get it, refusal is not proven, which I love.
I haven't had to argue this issue in probably 18 years. And every other time that, we've looked at it, the right to counsel has been violated in a refusal case. I mean, it was Stillman being overturned. But we all just looked at it and said, look, right to counsel is violated. It's a refusal case. That's it. We all walk away. But this was actually an analysis here about whether or not you need to do a charter analysis to look at admissibility of evidence, or whether or not that's it. The actus reus is not there because 10B is violated. And ultimately, yeah, it's a nice, clear decision on that, because the judge says, look, your right to counsel is violated. The whole idea here is that you are subject to this demand, and you're entitled to legal advice before you do it. You are just entitled to that legal advice, entitled to your right to counsel. As soon as you've established the right to counsel violation, and it could be before or after the demand is made, then that's it. You cannot commit the wrongful act.
Yeah. So the court ultimately comes to the conclusion that in the modern world, it makes perfect sense to give somebody access to the internet to find a lawyer, because like what you just said, used to be able to look at the phone book, but now, we're not paying $12,000 a month to be in the phone book. We're not in the phone book.
They pushed me for years to get in the phone book. I haven't seen a phone book in probably 15 years now.
One used to be dropped off on the doorstep of my old house. Place I rented. They would drop them off, and it would sit there and sit outside. And
the last place I saw a phone book was in the old Abbotsford Courthouse barristers interview room there. Yeah, yes. And it was already a 10-year-old phone book at that point.
Yeah. So the court says, especially where she's saying she wants access to the internet, there's no officer safety issue. Clearly, the police have access to the internet because they've used it themselves, and there's no basis to deny this. And if you're concerned that they're going to do something nefarious online, you can make the internet access supervised.
So many different ways you could do it. I mean, you could sit there with her and say, look, I understand you wish to research to find a lawyer. That makes sense. But you can't send emails, you can't send messages, and you can't call anybody on your phone. Yeah. You can only use it for the purpose of the research. Once you've got the number, I have to make the call for you because it's got to go out on our line.
Yeah.
And there's policy reasons
actually a lawyer.
And good reasons for this that are established in law. And that's all you have to say to somebody, and you could let them use their phone. Or you could set them up on a computer terminal. You can sit far enough away that you can't see what they're doing, because I think there may be a potential 10B issue if you are in some way interacting with them when they're searching, or it could be perceived that you're supervising their search. But if you're far enough away that you can see that they're not using Gmail or something like that, that's all you really are entitled to do, I would think, to supervise it. And certainly if you don't do that and somebody asks to do research, I don't even think they have to be as clear as she was. She was very clear. Give me my phone or let me access the internet.
Yep.
when she was released, the next day, it took her 20 minutes to find her lawyer. And
So Google 24-hour top DUI lawyer or something
I
like
don't think so. No, that's what they were saying they could have Googled. I think she Googled something else in the morning.
No, I think she gave the evidence that that's what she Googled the next morning.
Could
I'm going to find this here.
Yeah,
Uh,
that comes up a couple times, but her search is late in the decision there. But in any event, she finds the lawyer she ultimately hired to defend it, who did a good job.
She went home and performed a Google search for a 24-hour top DUI lawyer.
Oh, there you go. So now we know what keywords we would have to focus on with Google.
Well,
For our top DUI lawyer. She's in Toronto, though, I think, somewhere. It's an Ontario decision. So the decision is R. and Stewart, 2025 ONCJ 446. Of course, these are on Canley. And this one is also brand new. When did it come out? The decision released August 28th.
there you go.
New case law on the Driving Law podcast.
All right. It's time for the ridiculous driver of the week. This one I like. I like because it reminds me of that meme of the person who uses the raccoon to blow their interlock device, which is fake. That's a fake story, by the way, but it reminds me of that. So this is a motor vehicle accident, and it was actually 3 vehicles involved in the accident. And when the police were investigating how this accident happened, the driver blamed the accident on raccoons.
I mean, we're sticking with CanCon for the ridiculous driver of the week as much as we can these days. I can see people stopping for raccoons and causing an accident, but we also had a woman who was convicted of dangerous driving, causing death, for stopping for baby ducks in Quebec. That decision has never sat right with me. We had a client once who swerved for a raccoon on a road where there was nobody. Not quite nobody. There happened to be one person, lost control of his vehicle because of avoiding a raccoon. So they do cause accidents. Animals do cause accidents. And honestly, I'd plow right through a raccoon.
Well, this person stopped to let the raccoons cross and ended up in a 3-car pileup. So yeah, I mean, like the moral of the story is kill the animals, which is like tragic and terrible.
Well, it's different if it's somebody's pet than it is if it's a raccoon.
If you see Wrigley on the road, do not run over him, or I will come after you
Well,
personally.
no, I'm just saying, like, if it's somebody's pet, it's a very different thing. If it's a raccoon, a pest, a animal that is harmful to our current society, there's no shortage of them. There's no, they're not on any endangered species list. I would say not stop for them unless you're concerned about damage that it's going to cause your car. But if you're going to cause an accident, that's going to cause more damage then. So is it a ridiculous driver? I think it's more of a...
It's a lesson from a ridiculous situation.
Yeah.
Raccoon, 3-car pileup.
3 cars. How much is the thousands
$1,000 of damage estimated.
Were they ticketed?
It wasn't clear in the news story. I imagine they would have been for probably drive without reasonable consideration.
Well, they have a defense of showing reasonable consideration to the raccoons. But I think it's reasonable consideration for other road users.
All right. Well, that's our podcast. And if you have a driving law related issue or you're Googling 24-hour top DUI lawyer and you've landed here, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.